Hi. Hello. Hello. Hello, hello. Hi. We're back. Yay! We're finishing up Menendez Brothers tonight. Hello. What's up? Oh boy, do we have a lot to talk about. Menendez Brothers and everything else. Welcome. Hello. Happy Monday. I hope you all had a good weekend. We're finishing up Menendez Brothers habeas document, part 2. So it's not too long. And then we have a Karen Reed live. So let me say hello to everyone. Hello, welcome. I see Tipsy, I see Fem, I see 𝗟𝗏𝗃, I see Pantera. Hello, number 7. Hey Jules. Hi love. And I see Barbosa. Hello, welcome. Just walked in, door from work. Nice. Oh, Laura, I didn't miss you, Laura. Hi, Laura. Hi. Thanks for being here. Yeah, we're gonna finish this document tonight. I'm slacking a little. It's been a couple days since I did part 1, but it'll be linked down below. It always directs you to. I'm gonna set it up so it directs you from part 1 to part 2. But it was like 90 pages, so we have a few to get through tonight, and then we'll move on to another live later tonight. But hello, welcome. Thank you for being here. So, hey, Small Dog, good to see you. Yeah, I hope you're doing well, and Barbosa. We left off on part of the court transcript, so we're going to continue from there. Hey, Dodge, good to see you. Let's get started. So, fabricating evidence during trial. After the first trial, the prosecution discovered 𝗟 Menendez had spoken with the reporter Norma Novelli during the first trial and that the conversations had been recorded. In one conversation, 𝗟 Menendez discussed his plan to discredit Dr. 𝗂𝐚𝐬𝐡𝐀𝐩eh because petitioners had confessed to Dr. 𝗂𝐚𝐬𝐡𝐀𝐩eh that they had murdered their parents. 𝗟 would fabricate evidence that Dr. 𝗂𝐚𝐬𝐡𝐀𝐩eh was attempting to blackmail petitioners. If you don't know, hi, Being Bio Girl. Hi. We're covering the Menendez Brothers motion for resentencing that got denied by the district attorney. We watched the presser. We read the first half in the first live, so make sure you catch up. Good to see you, Being Bio Girl. I'm glad you made it. 𝗟 Menendez told Novelli, his tapes supposedly, like he says, a week later, right? But in any case, my thinking is that too, tell a story, talk about him coming. Nuh-uh. See, 𝗟 says, see, and us having a meeting of some sort on which he basically says, I have this tape, and maybe plays the whole tape or a portion of it, and that it's blackmail meeting. You know what I'm saying? Noel says, yeah, right. And 𝗟 says, and because I'm going to have to make something up to show this guy's motive, because sometimes people can lie too convincingly. Or maybe blackmail. He wants money. I can't figure out which it is. Maybe a combination or something like that. And Noel says, yeah, okay. 𝗟 says, and how the meeting would take place, and then this and that, and the things would be said because I'll have to recount all that. What I may then do is use a witness that'll say, yeah, 𝗟 said he had to go to this meeting with the psych at the restaurant. Noel, 𝗟 says, he came back and was real frazzled and everything. Something like that might be good. You know what I mean? Noel says, yeah, okay. And 𝗟 says, that gives me a little more time to set that up because then I don't know. By Monday, I don't need to know till I testify. In this recording, 𝗟 Menendez articulated his plan to perjure himself and potentially have another witness provided perjured testimony to support his blackmail claim against Dr. 𝗂𝐚𝐬𝐡𝐀𝐩eh. Ultimately, 𝗟 Menendez tried to discredit Dr. 𝗂𝐚𝐬𝐡𝐀𝐩eh during the first trial by claiming Dr. 𝗂𝐚𝐬𝐡𝐀𝐩ehe had a financial motive to lie, and petitioners were Dr. 𝗂𝐚𝐬𝐡𝐀𝐩ehe's hostages because of their confession tapes. 𝗟 Menendez testified to the following. Question, and it was your feeling that if he came to you with some suggestions about how to invest that money, that you'd go along with him? Answer, well, I didn't feel we had a lot of choice about going along with him. Question, why? Just, he said he had tapes in safety deposit box. He was very nervous and uncomfortable. There was no confidentiality since he felt threatened. He could go to the police. The sense I got was that he was under a lot of stress and would have trouble working and wanted to be compensated by being able to help us invest and us going into business together, and we would both profit. He didn't want me to just give him money. He wanted to be legitimate, but he wanted to be involved, and he had lots of good ideas. It is against this well-established backdrop of petitioner's deception and evidence fabrication that we analyze petitioner's new evidence claims. Hello, Knight. Good to see you. Yeah, it's Monday. Oh, happy St. Patty's Day, by the way. Hello, yes. Happy St. Patty's Day. Memorandum of points and authorities. Habeas corpus relief is extraordinary relief from a judgment that is presumed valid. Society's interest in the finality of criminal proceedings justifies this presumption, which is necessary to deter use of the writ to unjustifiably delay implementation of the law and to avoid the need to set aside final judgments of conviction when retrial would be difficult or impossible. The law is clear. Once a defendant has been afforded a fair trial and convicted of the offense for which he was charged, the presumption of innocence disappears. Thus, in the eyes of the law, petitioner does not come before the court as to one who is innocent, but on the contrary, as one who has been convicted by due process law. For purposes of collateral attack, all presumptions favor the truth, accuracy, and fairness of the conviction and sentence. Defendant thus must undertake the burden of overturning them. In a habeas proceeding, the burden of proof is on the petitioner to establish by a preponderance of substantial credible evidence the contentions upon which he seeks habeas relief. Because a petition for a writ of habeas corpus seeks to collaterally attack a presumptively final criminal judgment, the petitioner bears a heavy burden initially to plead sufficient grounds for relief and then later prove them. All facts upon which petitioner relies to overturn the judgment must be proven true. Thus, to satisfy his burden, petitioner must set forth fully and with particularity the evidentiary basis for each claim, along with reasonably available documentary evidence, including affidavits and declarations. Statements that are not made under penalty of perjury lend no evidentiary support to petitioner's claim. So we know the DA is not for them getting a resentencing hearing, right? In this case, the court had ordered an informal response to petitioner's instant habeas corpus petition. An informal response may assist the court in determining if the petition sufficiently states a prima facie case for relief and whether the claims are procedurally barred. If the court determines that the petition does not establish a prima facie basis for release or that the claims are procedurally barred, it may summarily deny the petition without issuing an order to show cause or an evidentiary hearing. Respondent files this informal response to assist the court's determination of whether the petitioners are procedurally barred from raising any of the current claims and whether they have made a prima facie case for habeas relief. For the reasons discussed post, petitioner's new evidence claims are procedurally barred and fail to make a prima facie showing for habeas relief. This honorable court should deny the petition without the issuance of an order to show cause of or necessity of an evidentiary hearing. Before delving into the applicable procedure bars and the substantive failures of the petitioner's instant new evidence claim, it is critical to address the fundamental flaws in the premises of these claims. Petitioners found their new evidence claims on this straw man fallacy. Jurors had to decide a single question: was Menendez molesting his sons? This argument completely misstates the law and the questions their convicting jury were required to answer. The three questions before the convicting jury were: number one, did petitioners conspire to murder their parents? Number two, did petitioners kill their parents? And three, what were the petitioners' respective states of mind when they collectively shot their parents over 12 times with shotguns, killing them? To support their misleading argument, petitioners rely on the similarly misleading assertion that sex assault evidence was excluded at the second trial. Through such specious argument and assertion, petitioners endorse their faulty conclusion that they were only convicted in the second trial because of the exclusion of the sexual assault evidence. In this way, petitioners attempt to create a foundation that their two pieces of allegedly quote-unquote new evidence, the Cano letter and the Rosella Declaration, are each sufficiently material and credible that each more likely than not would have changed the outcome of the case. But petitioners' faulty conclusion disintegrates in the face of crucial facts they omit in advancing it. Number one, assault evidence was presented in the petitioner's second trial. Number two, Petitioner Joseph L. Menendez chose not to testify in the second trial. 3. New evidence of petitioner's guilt was presented in the second trial. And 4. New evidence of petitioner's attempt to fabricate evidence was presented in the second trial. To create the false impression that 𝗟𝐸ITG assault evidence was not presented at the second trial, the petition points to the 47 source witnesses who did not testify in the second trial. As noted by the Ninth Circuit Court of Appeal, 𝐿𝑖TG and 𝗟𝗏 sought to introduce testimony that could explain why they feared their parents. These witnesses were referred to by the trial court so-called source witnesses, people who had observed certain things, either observed the interaction of the defendants with their parents or gave character evidence relating to their parents, things of that nature. Their assertion is misleading for a myriad of reasons. Initially, in the second trial, the defense introduced a plethora of sexual abuse evidence. As the Ninth Circuit Court of Appeal noted in the second trial, the defense did present evidence that Jose had repeatedly abused his son and that Kitty had a 𝗟𝐼ced for most of their lives. 𝗟𝗏 testified that Jose had threatened to kill him even if he revealed the abuse. According to 𝗟𝗏, there had been several confrontations between Jose, 𝐿𝑖TG, and 𝗟𝗏 days before the unalivings. 𝗟𝗏 testified at extraordinary length and in incredible detail about his childhood and his relationships with his parents, beginning with his allegations that his father began molesting him at the age of 6, following through incident by incident until he was 18. 𝗟𝗏 testified that in the days leading up to the unalivings, he had fear that at some point his parents would unalive him, a fear that fluctuated in intensity during those final days. This is the biggest case of his life and give him an excuse to stand on his soapbox. The Ninth Circuit Court also noted, 𝗟𝗏 testified about the alleged abuse in great detail for roughly 7 full court days. In addition, Brian Anderson, a cousin of 𝐿𝑖TG and 𝗟𝗏, testified about severe physical abuse that the petitioner suffered at the hands of Jose. 𝗟𝗏 testified about physical and verbal abuse by both Kitty and Jose. Andy Cano, also a cousin, testified that 𝗟𝗏 confided to him that Jose was molesting 𝗟𝗏. Cano testified also that 𝗟𝗏 always had bruises on his body. Several witnesses testified that when Jose was alone with one of his sons in the bedroom, no one was allowed to go near the bedroom. Dr. 𝗏 testified that 𝗟𝗏 suffered from an anxiety disorder that could affect his mental state. In addition, Dr. Wilson testified that 𝗟𝗏 suffered from battered person syndrome, depression, and PTSD. Indeed, as the Ninth Circuit Court of Appeal remarked, the defense was, as discussed above, allowed to present substantial evidence relating to the allegations of abuse. Indeed, 𝗟𝗏 testified for 7 days about the various types of physical, mental, and abuse he claimed that his father inflicted. But when asked on cross-examination, 𝗟𝗏 admitted that despite years of alleged abuse, there was no witnesses who could testify that they had ever seen Jose hit his sons. 𝗟𝗏 was unable to name a single person who had ever even asked 𝗟𝗏 about the bruises and welts he claimed his father had inflicted on him for years. Second, while the trial court did limit the presentation of abuse evidence in the second trial, it did so on multiple legal grounds. For example, the trial court ruled, however, that the defendants were required first to lay a foundation, which in the case could only be accomplished if the defendants testified about their actual belief of imminent danger. And indeed, we too see no other competent way in which the foundation could have been laid. 𝗟𝗏 took the stand, but 𝐿𝑖TG chose not to testify. Further, during the second trial, the prosecution successfully argued that some so-called source evidence that would have explained why the brothers might have a fear of their parents, was cumulative or lacking in foundation. These witnesses included family and friends who would have testified to specific instances of abuse by Kitty and Jose. The evidence also included experts who would have explained that the effect of the abuse might have on 𝐿𝑖TG and 𝗟𝗏. The trial court had excluded or limited some of the testimony as either lacking foundation or because it was cumulative. In excluding this testimony from the second trial, the trial court noted, quote unquote, based upon what I heard during the first trial and all the evidence presented during the first trial, this primarily constitutes character evidence of the character of the decedents and is not relevant or probative on any issue in the case. And also the potential of prejudice does not substantially outweigh the probative value. In upholding the trial court's ruling, the California Court of Appeals stated, the trial court stated the principal issue was a state of mind of the defendants at the time of the killing, and the relevant prior incidents may have had on the defendant's mental state at the time of the killing. The source witnesses were allowed to testify extensively concerning many areas in effort to determine the state of mind of the defendants at the time of the killing. We find no abuse of discretion in the trial court's limitation or exclusion of some source witness testimony. Critically, none of the source witnesses whose testimony was excluded in the second trial provided or had any personal knowledge about the alleged sex abuse. In fact, in the instant petition, petitioners particularly alleged the only witnesses who had any knowledge of the abuse was 𝐼𝐼𝐿. Ms. 𝐼𝐿 did not have any firsthand knowledge of any abuse occurring. Moreover, while the petitioner further alleges at trial much of the defense evidence, including 𝐼𝐼𝐿's testimony, was excluded, the trial court did not exclude Ms. 𝐼𝐿 from testifying in the second trial. Ms. Vander Molen's fresh complaint testimony was made inadmissible by Lyle Menendez's personal decision not to testify. Also, contrary to their arguments, the trial court did not limit Eric Menendez in presenting any sexual assault evidence in the second trial. In fact, Mr. 𝐂𝐚𝐬, the sole witness who corroborated Eric Menendez's assault claim, testified in both trials. Moreover, even though Lyle Menendez chose not to testify in the second trial, Eric did testify and was given the option of reading and Lyle Menendez's testimony for the first trial to jury in the second trial. But as the California Court of Appeals astutely noted, Eric Menendez made a tactical decision not to request the transcript of Lyle's previous trial testimony be read to the jury. This decision avoided extensive impeachment regarding Lyle Menendez's lies before, during, and after trial. Lastly, petitioners argue that the assault evidence or any evidence was improperly excluded is not new, is misleading, and is unfounded. Petitioners' counsel unsuccessfully advanced in the argument on appeal in the prior habeas petitions. Both the California Court of Appeal and the Ninth Circuit Court of Appeal reviewed and rejected the argument in upholding the trial court's decision to exclude the 47 witnesses and noting that those witnesses would not provide evidence of sexual assault. What up, prison guard? Good to see you. It's good to see you in chat. 2. Lyle Menendez chose not to testify in the second trial. In the second trial, Lyle Menendez chose not to testify, a decision that was his only to make. Arguably, his decision to not testify in the second trial was based in part on law enforcement's discovery that the petitioners had tried to or fabricated evidence. After their first trial concluded and before their second trial commenced, the Beverly Hills Police Department discovered multiple incidents of both petitioners attempting to or succeeding in manufacturing evidence. One such piece of contrived evidence was a letter Lyle Menendez wrote to Brian 𝐿𝐿. As discussed above, Mr. 𝐿𝐿 had been Eric Menendez's classmate and had visited petitioners while they were in custody on the underlying case. Lyle sent a letter to Mr. 𝐿𝐿 on July 9, 1991, providing him a script of perjured testimony that he wished Mr. 𝐿𝐿 to testify to in the petitioner's trial. Since the 𝐿𝐿 letter was not discovered until after the first trial, it would have been the subject of cross-examination against Lyle Menendez in the second trial. Thus, in choosing not to testify in his second trial, Lyle dodged that inquiry in court. Specifically, Lyle avoided having to answer questions about the letter that directly contradicted his previous testimony in the first trial. In the first trial, before his letter was discovered, Lyle testified about petitioners' collective efforts to buy the suspected firearms. Question: where did you first go? First, we went to the Big Five in Santa Monica, and then eventually we ended up in San Diego at 2 stores down there. And when you went to the Big Five, that's when you discovered that there was a 15-day waiting period before you could purchase a handgun, correct? Right. Yet, in the 𝐿𝐿 letter, Lyle asked Mr. 𝐿𝐿 to testify to a false narrative about how and when the petitioners obtained a firearm that included events on August 19th. So you stopped asking questions and said, yes, you have one handgun at the house. We all drove back and you ran in and got it. Lyle took it and they said that they would be in touch. We then drove off. You told nobody about the incident and you were very nervous that we were in trouble. The gun you gave was loaded. You didn't give any ammunition with it. You told Eric not to let the lawyers know about actually giving us a firearm because the firearm is illegal and your mom would freak out. I have an untraceable firearm I can get for you to use the one you gave us if you don't already have one. Let me know over the phone. I'll have Beatrice get it for you if necessary. This letter completely contradicts both petitioners' testimonies in the first trial as to why and when they purchased the firearms. By choosing not to testify, Lyle did not have to answer questions about his scripted Islamenia letter, address its contradictions with his previous testimony in the first trial, and lose credibility with his second jury. Oh, thank you, Widow. That's really nice. That's really nice. Yes, Laura, free Karen. We're covering her. Yeah. In the first trial, petitioners had separate juries. Eric Menendez's first jury did not hear evidence from 𝗵𝗵𝗿𝗲 and Lyle Menendez attempting to elicit perjured testimony that Jose Menendez had raped her, but Lyle Menendez's jury did. By not testifying in the second trial when petitioners had one jury, Lyle did not have to admit to the second jury that he had brazenly tried to bribe his girlfriend and to falsely testifying that Jose Menendez had assaulted her in a scenario that mirrored a storyline in the movie At Close Range. In another example of evidence manufacturing after petitioner's first trial, the Beverly Hills Police Department discovered a letter Lyle had written to 𝗟𝗏 Baker instructing her on how to testify at trial. Ms. Baker was one of Lyle Menendez's girlfriends and was a witness in the first trial. In the Baker letter, Lyle Menendez directed Ms. Baker as follows. All right, 𝗟𝗏, this is the information we discussed on the phone about visiting Eric. I'm going to get right to the point because after you read this and feel you've absorbed it, I want you to throw it away. Do that right away so you don't forget. Maybe you can take some notes in your handwriting. Okay, well, basically there are two incidents. They may seem strange and irrelevant to my case, but I assure you they will be very helpful. You'll just have to trust me on it. Later on, I can explain why, but for now, I'll just lay them out. I have given a lot of thought to this, and I really feel you can do it. However, just let me know if you'd rather not. Lyle Menendez then instructed Ms. Baker to testify that Kitty had tried to poison her family. Quote unquote, all of a sudden, Mr. Menendez said in a stern voice to Miss Menendez, who had been standing behind you, what did you do to the food? And Mr. Menendez shoved his plate forward, knocking over some stuff. Therefore, after the first trial, Ms. Baker testified almost verbatim to what Lyle Menendez had instructed her to say. Question. When Mr. Menendez put the food on the table, did something unusual happen? Response. Yes, she was standing behind me. So I don't know if Miss Menendez. She was standing behind me, so I don't know if she did something to provoke her husband, but before I knew it, he had stood up and pushed his plates out of the way very violently, knocking over all sorts of glasses and condiments, whatever was on the table, and said something like, what did you do to this food? Why are you serving this food? Also in the Baker letter, Lyle directed Miss Baker to testify. Lyle got up immediately and said, come on, 𝗟𝗏, and we both walked out in the foyer. Eric walked out too. You got your purse and jacket. We walked outside and stood in front of the big Mercedes. As directed, Miss Baker testified in the first trial. Lyle motioned me to come with him. I was able to grab my purse and coat and whatever else, and we went out front to where the cars were parked. In the Baker letter, Lyle further instructed Miss Baker that she should testify. Either Eric or I said to him, What's the matter, Dad? You think she tried something? Then Miss Baker testified in the first trial. Eric had asked his father something. Do you think she tried something on purpose or something like this? Lastly, the Baker letter included the following instruction to Miss Baker to testify that they all had ended up eating at Hamburger Hamlet. Miss Baker did exactly that and subsequently testified in the first trial. We went to eat at Hamburger Hamlet. Significantly, in the first trial, Ms. Baker testified immediately after Eric Menendez testified. In the first trial, Eric Menendez also testified about the alleged poisoning incident. Question. In the fall of 1988, do you remember an occasion when Ms. Baker was at your home in Beverly Hills for dinner? Yes, I do. And did something unusual happen? Yes. What would you tell the jury happened? She was overeating dinner and my mom was serving. Apparently, the maid was off. or something like that. And we were all sitting down at the table, and my mom had served dinner, and my dad pushed the tray away, his plate, toward my mom and spilled something and told my brother and I to get up from the table. Now, do you recall whether or not your father said anything to your mother as he pushed the plate away, or at any time during this? Yes. What did he say? He looked at my mom and then said something like, "What did you do to the food?" or "What are you up to?" or something like that. What, Mr. Menendez, did you believe was going on? I believe that my dad thought my mom poisoned the food. Although Ms. Baker was called as a defense witness in the first trial, after the Baker letter was discovered, petitioners did not call her as a witness in the second trial. The people did not attempt to call her as a witness in the second trial because, as they said in trial court, they anticipated she would invoke her Fifth Amendment right against self-incrimination. The trial court ruled that the Baker letter could not come in as evidence in the second trial unless Ms. Baker testified. Therefore, by not calling Ms. Baker as a defense witness in the second trial and by choosing not to testify in the second trial, Lyle evaded the possibility of a second jury learning that he had also tampered with Ms. Baker's trial testimony. Hey, Irony. Oh, hey, you're late, and you're late, Austin. Detention for both of you. I know, I saw that. Fem. What do you guys think? Menendez brothers, should they be free? 30 years was long enough, and that was important evidence that was left out. I agree. It's kind of hard to defend. It looks premeditated. Yay! Thank you, Laura. Thank you for standing with me. Hey, Razon. Yeah, I know that's going to be crazy. Okay, let's move on. As discussed in Section B, between the first and second trials, the prosecution became aware of audio recorded conversations with 𝗏𝗏, wherein Lyle Menendez openly discussed fabricating evidence and perjuring himself to try to discredit his recorded confession to Dr. Oziel for why he had killed his parents. In choosing not to testify in his second trial, Lyle Menendez eluded the prosecution's possible cross-examination on his credibility, shattering evidence of his own making. Yeah, I know I'm going to cover that. I think I should definitely cover that, being by a role in them. New evidence of petitioner's guilt presented in second trial. At petitioner's second trial, the prosecution presented new evidence to show petitioner's motive for conspiring to and ultimately killing their parents and to refute their previous claims and testimony of how they murdered Kitty and Jose Menendez. Testimony of Clara and Randolph Wright. The prosecution presented witnesses Clara Wright and her husband, Randolph Wright, for the first time at the second trial. The Wright's son had played tennis with Eric. The morning after the unalivings, Miss Wright went to the Menendez house to pick up some of her son's tennis rackets. When she arrived, she observed a lot of police cars and saw Eric, and Eric said to her, "Miss Wright, I'm so glad you're here. We need to speak to your husband." And he said either that he was trying to get a hold of him or that he wanted to get a hold of him. Randolph Wright is an attorney. Miss Wright told Eric to come to her house that day at 3:30 as Randolph Wright would usually be home at that time. Petitioners went to the Wright's house that day. Eric asked Clara when he first got to her house if she knew anyone who was good with computers because he suspected there was a will on the family computer. Miss Wright testified about Eric Menendez. She said, just wanted to make sure about Eric Menendez. Just wanted to make sure that there wasn't one will in there. He wanted to make sure that he had already checked and he couldn't find nothing, but he's not that great. And with the computer, that maybe if somebody was good at it, they could go into different compartments to make sure there's no will there. When Mr. Wright came home, he spoke to the petitioners, and at one point, they asked my husband if it's illegal to write a will in a computer. And as I remember, my husband said that he didn't know the answer to that, but he would check into it. Miss Wright testified that the petitioners had been concerned about a possibility that Jose had written a new will that was on the computer. Miss Wright also testified. Question: what do you recall either or both defendants actually saying concerning a will in the computer? Miss Wright says, just that they had to have locate the wills. There may be two of them. Question: what do you recall either or both defendants saying about the possibility of their father having changed or was working on a will? Response was just that possibly he was starting a new will. And do you recall as you sit there which of the defendants or both said this? That was both of them talking at different times. Ms. Wright testified that once it was mentioned that a will might be in the family safe, both petitioners left the Wrights' house to go home and locate the safe. Petitioners returned to the Wrights' house with the safe. Mr. Wright testified about his interactions with the petitioners on the day after they had murdered their parents. Mr. Wright testified that he had asked the petitioners if they knew who had killed Jose and Kitty Menendez, and Lyle had told Mr. Wright that he believed the mafia had committed the crime. Wow, I did not know this. We put people in most jails. Most of them don't get the opportunity to work classes. Rehabilitation is ridiculous. Yeah, they're going to like all these UCs and stuff. We are locking up people way too long here. It's ridiculous. What purpose does it serve? Menendez do need a second chance, only my opinion. Okay. They didn't get a deal from the DA, or they didn't take one. They committed first degree unaliving and it was double homicide. They took a chance and lost. Good point. Didn't one of the brothers just get caught? Yes. I went to jury only because I was never offered a deal. Interesting. Okay, let's move on. The prosecution presented to the jury evidence from pathologist Dr. Robert Lawrence and accident reconstruction expert Dr. Roger McCarthy in the second trial. Combined, this evidence belied petitioner's contention in the first trial that Jose Menendez had been standing and moving toward them when petitioners had started unaliving their parents. Instead, the new evidence clearly established petitioners had executed Jose and Kitty while they were sitting down. Specifically, pathologist Robert Lawrence testified that Jose and Kitty Menendez had been killed by multiple shotgun wounds. Jose was struck 4 times and Mary was struck with 9 blasts. Of the 4 shotgun shells that had struck Jose, 1 had caused an explosive contact wound in the back of his head. This was a lethal wound. Dr. Lawrence explained that an explosive contact wound meant the muzzle of the shotgun was in contact with the back of his head when it was fired. Dr. Lawrence further explained that the shot had been fired from back to front and in a downward angle. Dr. Lawrence stated that Kitty had been shot 9 times by 2 different types of shotgun shells, 7 times with buckshot and twice with birdshot. Dr. Lawrence described the wounds as follows. She was struck in her left breast area from the side. She was struck from the front in her face, another through her right and onto her collarbone area on the right side, another that went through the forearm and upper arm, so that both of these shots were received when the hand was held against her chest. And then there was a perforation of her right thing and 2 wounds of her. Perforation of her right thing and 2 wounds of her. I'm sorry, her left thigh and 2 wounds of her left knee area. Finally, the birdshot wounds were the ones that went up through her left shoulder and struck her in the left side of the face. And the other was a contact wound in the left cheek. The muzzle held against her cheek was birdshot was fired into her head. That's kind of brutal. Dr. Lawrence testified that Kitty Menendez's contact wound to her left cheek indicated that someone had placed the muzzle directly on her skin when firing the shot. That's like overkill, right? Premeditation. I don't know. I don't know what to think. In addition to Dr. Lawrence, accident reconstructionist Dr. Roger McCarthy testified about the sequence of the shots fired. Dr. McCarthy testified that both Jose and Kitty Menendez had been seated on the sofa at the time of their first shot and that it had passed through the left arm and right arm of Jose and the breast of Kitty Menendez. McCarthy testified the second shot had been a contact wound to the back of Jose Menendez's head. Dr. McCarthy testified that Kitty Menendez had moved off the couch, causing the third shot to miss her. Dr. McCarthy testified that the 4th shot hit Kitty Menendez in the right side of her face. The 5th shot had been fired at Kitty while she was on the ground between the sofa and the coffee table and had struck her in the right lower forearm and her upper right arm near the shoulder. The 6th shot struck Kitty in her right hand, upper throat, chin, and clavicle area. The 7th shot hit Jose Menendez's left upper leg. Dr. McCarthy testified that he could not specify if the shot 7 had been before or after the shots to Kitty's legs. Shots 8 through 10 had been fired at Kitty while she was on her back and struck her left leg. The 11th shot was birdshot, a different type of ammunition from the previous 10 fired rounds, and struck Kitty Menendez in the face and on her shoulder. Before the 11th shot was fired into Kitty Menendez's head and shoulder, she rolled onto her right side. The 12th and final shot left a contact wound to Kitty Menendez's left cheek. The testimony of Drs. McCarthy and Lawrence proved that Jose and Kitty had been shot while they were sat on the sofa. Through this and the other trial evidence, the prosecution was able to show petitioners had shot both of their parents in the knees to make it look like a mafia killing. The mafia-style killing of the parents was the original lie petitioners had told family, friends, and law enforcement. This evidence further corroborated the prosecution's position that were premeditated murders committed while lying in wait and pursuant to a conspiracy to commit unalivings, not in the heat of passion. With all the additional incriminating evidence in the second trial pointing to petitioner's guilt for murder and conspiracy to commit murder, petitioner's second jury heard more evidence proving their guilt than their first juries. In response to Eric Menendez's attorney's closing argument that the second trial jurors were the third jurors to hear the case, the prosecution rebutted, "Ladies and gentlemen, you are the jury, as you know, who was the only jury to hear from Rogers McCarthy. He said he never previously testified in regard to this matter. You are the only jury, ladies and gentlemen, to hear about a reconstruction of the evidence in this case, to look through the eyes of Roger McCarthy at what happened in that room. The first jury to hear through the eyes of and see through the eyes of Roger McCarthy that there are reasonable conclusions that can be drawn concerning how brutally Kitty and Jose Menendez were shot to death on August the 20th of 1989. And you know that you are the first jury to hear the testimony of Clara Wright and Randy Wright, who did not come forward until after the first trial. Clara and Randy Wright, who provided evidence of the greed motive of defendants within hours of shooting their parents to death. And you know that you are the first jury to hear evidence from Brian Islamenia, who never came forward before. You know that you are the first jury to hear that there was in fact a plan on the part of both defendants, according to the prior statements of Brian Islamenia, to fabricate and trick a jury in this case. And ladies and gentlemen, you know that you are the first jury to hear from Park Dietz, who told you in so many words that this crime, that the actions of the defendant Eric, and that the time of commission of the crime is only consistent with deliberate behavior that is reflective thought and is inconsistent with some notion of automatic behavior. As the prosecution clearly explained to the second trial jury, substantially more evidence of the petitioner's guilt for murder and conspiracy to commit murder, attempts to fabricate evidence, conspiracy to commit perjury, motive and impeaching evidence that was presented against petitioners in the second trial. For these reasons, petitioners sensationalized yet baseless allegations. They were only convicted in the second trial because the trial court allegedly improperly excluded evidence of sexual assault evidence fails. No evidence supports petitioners' assertion that their two pieces of allegedly new evidence, the Cano letter and the Roy Rosello's declaration, are each sufficiently material and credible that each more than likely would not have changed the outcome of the case. Recent legislation has modified the standard for analyzing claims of new evidence on habeas corpus. In 2023, after petitioners filed the instant petition and after this court requested an informal response that was partially based on specific elements of the prior definition, the legislator again amended the language of Section 1473 and redefined a petitioner's burden when raising a claim of newly discovered evidence on the habeas corpus. The new law became effective January 1st, 2024. Subdivision, the rewritten statute now requires a petitioner to establish the following for habeas relief on claim of new evidence. New evidence exists that is presented without substantial delay and is admissible and is sufficiently material and credible that it is more than likely would not have changed the outcome of the case. For purposes of the section, new evidence means evidence that has not been previously presented and heard at trial and has been discovered after trial. Though the legislator has amended the statute relating to new evidence claims on the habeas corpus, petitioners have not met their burden to even under have not met their burden even under the revised statute. The 𝐵 letters does not constitute new evidence on habeas corpus. Here, petitioners claim the 𝐵 letter that Eric Menendez purportedly sent Mr. 𝐵 is newly discovered evidence, but the 𝐵 letter does not constitute new evidence under the definition of the section. This point is clear. At best, the 𝐵 letter is corroborative evidence that Eric Menendez told Mr. 𝐵 that his father was molesting him, a fact that both Mr. 𝐵 and Eric Menendez testified at both trials. Respondent recognizes that the current statutory definition of new evidence on habeas corpus does not exclude evidence that is merely cumulative, corroborative, collateral, or impeaching as new, even though the prior definition did. Yet the fact that the petitioners need no longer overcome the aspect of the prior statutory definition to make prima facie showing that the 𝐵 letter is new evidence does not mean that the 𝐵 letter satisfies the current definition. In fact, it does not. Do you guys believe that that's real? The 𝐵 letter and the Rosello documents? I'm curious. First, assuming arguendo that the letter was legitimately written by Eric in or around 1989, as alleged, is true. A futile exercise given his documented history of deceit. Eric Menendez presents his claim after substantial delay and contravention of the current statutory definition of new evidence. As its purported author, Eric Menendez knew about the 𝐵 letter when he wrote it approximately 34 years ago, before both of his trials. Yet he did not disclose the purported 𝐵 letter to his juries. Eric Menendez knew about the letter for 4 years before his trial commenced in 1993. Yet the first trial record is devoid of any mention of it by Eric. Even when the prosecution repeatedly questioned the veracity of the alleged abuse, Eric never mentioned or introduced the 𝐵 letter. Significantly, Mr. 𝐵, the alleged recipient of the 𝐵 letter, testified during the first trial for the sole purpose of claiming Eric Menendez had told Mr. 𝐵 that he had been molested prior to the petitioners unaliving their parents. Before testifying in that trial, Mr. 𝐵's credibility was also questioned based on a car he was gifted from Eric Menendez before testifying. It defies logic that Eric Menendez never examined Mr. 𝐵 about having received the 𝐵 letter or tried to reintroduce the 𝐵 letter into evidence through Mr. 𝐵 to salvage 𝐵's credibility. More incredibly, in the second trial, after having both testified before, neither Eric nor Mr. 𝐵 mentioned the letter. I didn't know that he had bought him a car. I did not know that. It's crazy to think they've been in there since I was born. I know, right? In a feeble attempt to excuse this substantial delay, Eric Menendez claimed that he first heard about the letter in 2015 during a 𝗟𝗶𝗸𝗲 special. His excuse falls flat. Allegedly having been reminded of the 𝐵 letter that he purportedly wrote in 2015 does not change the fact that Eric Menendez knew of the letter 26 years earlier in 1989, when he purportedly wrote it. Therefore, his presentation of the claim violates the section in two ways. He did not discover the 𝐵 letter after trial, and his presentation of the claim is substantially delayed. Lyle Menendez claimed to have learned of the letter almost 8 years ago in 2015. Assuming arguendo that this declaration is true, which given his extensive history of documented deceitfulness and evidence fabrication in the underlying case is also a strain, he too allowed years to pass before raising this claim. To justify their substantial delay in filing this habeas petition, both petitioners continue to lie. They stated they delayed in filing this petition because they believed an individual could only file one habeas petition. This anemic excuse is belied by the fact that both petitioners previously filed multiple habeas petitions. Lyle filed a state habeas petition on October 5th, 1998. Both petitions were denied. Eric filed a habeas petition on April 30th, 1999, and both were denied. Therefore, both petitioners filed federal habeas petitions challenging the underlying case, which the Ninth Circuit Court of Appeal denied. If Eric Menendez wrote the 𝐵𝐻 letter, he knew about its existence over 30 years before raising the claim. Lyle Menendez knew about this 𝐵𝐻 letter for at least 8 years before raising this claim. As noted above, a 5-year delay is considered substantial under California law. Therefore, both petitioners violate Section 1473 subdivision in presenting the 𝐵𝐻 letter after substantial delay, and such it is not new evidence on the habeas corpus. Second, the 𝐵𝐻 letter is not admissible evidence as it pertains to Lyle Menendez. The 𝐵𝐻 letter does not provide any evidence as to Lyle Menendez's state of mind at the time of the murders. Lyle Menendez fails to make a prima facie showing to the contrary. Thus, the 𝐵𝐻 letter is not new evidence on habeas corpus as it pertains to him. Third, the 𝐵𝐻 letter is not sufficiently material and credible that it is more than likely would not have changed the outcome of the case for either petitioner, a requirement of Section 1473 subdivision. At baseline, the issue of whether sexual abuse occurred is not material to whether the petitioners were entitled to an imperfect self-defense instruction. As a trial court and every reviewing court since has found, there was no immediate danger, and therefore petitioners could not argue imperfect self-defense. In this way, the 𝐵𝐻 letter, which purports to document a past of alleged molestation by Jose Menendez against Eric, does not evidence that the petitioners believed they were in imminent danger when they unalived their parents. Similarly, it would not change the court's trial rulings that the petitioners were not entitled to a heat of passion instruction as to Kitty Menendez, and that Lyle Menendez was entitled to a heat of passion instruction as to Jose. Moreover, the letter is inconsistent with Eric Menendez and Mr. 𝐵𝐻's testimony in both trials. In both trials, Eric and Mr. 𝐵𝐻 testified Eric Menendez had only disclosed alleged molestation to Mr. 𝐵𝐻 when Eric Menendez was 12 or 13 years old and that Mr. 𝐵𝐻 was 10. Both testified in detail that they had only discussed the molestation approximately 3 times that year, and neither made mention of a letter. In the second trial, Eric Menendez testified that he had been 12 or 13 years old when he had told Mr. 𝐵𝐻 about the alleged molestation. I didn't feel comfortable enough to talk to anyone about that except for Andy. Question. And when you say Andy, are you talking about your cousin Andy 𝐵𝐻? Yes. Did you tell Andy 𝐵𝐻 that your father was molesting you? In a way. How old were you when you talked to Andy? 12 or 13. What did you tell him? I just told him, well, I asked him first. I was trying to find out at this point whether any other fathers did this to their sons, and I was going through a period where I just wasn't sure. And I asked him if his father had done these things. I asked him if his father had ever touched him, his penis, before. What did he tell you? He said no. Did you go into specifics with Andy about what your father was doing to you? No, I just told him that my father was hurting me. I told him that my father was touching me. His father had divorced his mother, and so he wasn't quite sure if it was normal or not. He wanted to ask. He wanted me to talk to his mother. Eric Menendez further testified on the subject. You indicated before that Andy was the only person that you talked to about this. Is that correct? Yes. And did you indicated that you had told Andy some things. Did Andy ever say anything back to you after you told him the information that you told the jury? What do you mean by back to me? What did he say anything in return to like what you should do? He wanted me to talk to his mother, my Aunt Marta, about that, and I made him swear never to tell her about this. He told me that he would try and find out. I brought it up with him on several different occasions. I remember one time he was in my room, and I remember we were in sleeping bags, and I would tell him a little bit more of the information, and we would talk about it, but he was 2 years younger than me, so he didn't give extensive advice. Now, during the conversations, various conversations you had with Andy, did you actually tell him your dad was touching you? More than that. What did you tell him more specifically? I told him that my dad would touch my genitals and that I would touch his, and we would massage each other. I remember when I was in my room that he wanted to know more about whether it hurt or not, and I told him that it hurt, and he asked where, and I told him in my butt, and we talked about what that meant, and I tried to avoid what that meant and just different things like that. Did you ask Andy or make him promise anything about telling what you told him? Well, I made him promise never to tell his mother and his brother or in any way that could come back to my mother. Now, where is Andy today? He lives with no, I guess he doesn't. He's going to school in Florida. Did you ever feel that there was any person that could tell you that you felt close enough to you that you could tell about this besides Andy? No. In the second trial, Andy also testified that Eric had told him that about the alleged abuse by Jose. Now you're saying that when you were 10 years old, Eric was about 13. Is that correct? Yes. And that is when the statement to you was made. Is that correct? Which statement? That is a statement about his father touching him or giving him a massage. Yes. Mr. 𝐂𝐚𝐬 testified about the amount of times Eric Menendez had brought up the abuse. This is kind of brutal, huh? I know. I'm behind on the chat. You're good, Pantera. Thank you for being here. Did you ever talk about either subject matter or the same subject matter again after that? Yes. And how about how long later was it that you had another conversation? Approximately around a month. It was the next time I saw him at his house in Pennington, New Jersey. Correct. What was it about that you talked about on that occasion? He really wanted to know whether I had kept it a secret. He wanted to find out if I had told my mother, and basically after that concluded, we were talking about whether it was normal or not. Did he describe with any additional clarity or description what his father was doing to him at that time? No. Did he tell you or indicate to you that the massages that he described to you were something that was happening to him right then and there in his life at that time in his life? Yes. Did you ever talk about that subject matter again? I can recall one other time it was brought up. And when was that? Probably again, another couple of months down the line. Where was it that you were at when you had that conversation? We were in his bedroom in the Pennington house. And this is something that he brought up from time to time. He brought up several times after that. And over what period of time? Over within the year. How many times? 3 that I remember. Over approximately 1 year span? Right. Mr. 𝐂𝐚𝐬 also testified that besides his conversation on the subject with 13-year-old Eric when he was 10, the only other time he had spoke of the abuse disclosures were when he had first met Eric Menendez's attorney, Leslie Abramson, after Eric Menendez had been arrested for the murders and after Eric had gifted Mr. 𝐂𝐚𝐬 a car. Importantly, in the first trial, Mr. 𝐂𝐚𝐬 testified that Eric Menendez had never mentioned the alleged molestation to him after Eric had moved to California, in direct contradiction to petitioner's instant allegations regarding when Eric had allegedly written the 𝐂𝐚𝐬 letter to Mr. 𝐂𝐚𝐬. Mr. 𝐂𝐚𝐬 testified, when Eric was a teenager, did he strike that? After Eric moved to California, did he ever bring up the molestation by his father to you again? No. Did you ever bring up the subject again? No. When he would make a reference to problems in the family, he was very specific about what was going on that you can recall. No, I don't recall any details. He would just say something like, things with my parents are going really badly, something to that effect. As discussed, Mr. 𝐂𝐚𝐬 and Eric Menendez never testified about the 𝐂𝐚𝐬 letter in either trial. In both trials, Mr. 𝐂𝐚𝐬 and Eric Menendez's testimony were oddly consistent on the timing of Eric Menendez's disclosure of the alleged molestation to Mr. 𝐂𝐚𝐬. The specificity and consistency of their testimony is unusual given that the disclosures had allegedly occurred 8 years before they had testified in the first trial, and that Mr. 𝐂𝐚𝐬 had such great recall of what Eric Menendez told him when he was 10 years old. The 𝐂𝐚𝐬 letter contradicts Mr. 𝐂𝐚𝐬's testimony from the first trial that Eric Menendez had never broached the subject of the alleged molestation with him after Eric Menendez had moved to California. Eric testified that he had moved to California in 1986, 2 years before petitioners alleged that the 𝐂𝐚𝐬 letter was written. If the 𝐂𝐚𝐬 letter is genuine, it defies logic that neither he nor Eric Menendez raised the subject during his testimony. In the second trial, Mr. 𝐂𝐚𝐬 was given every opportunity to mention and or to produce the letter, but did not. First of all, I was very loyal to Eric in that sense. Also, it's not the really kind of question that a boy would really like to ask his mother. Sort of embarrassing. So did you ask your father? Response, no. Why not? It's not something that was important to me that it stuck with me for weeks and weeks or months until I saw my father. I was a kid and my mind was racing to different thoughts and different ideas every day. Did you ask any adult? No. Okay, but whether or not you kept it in your mind continuously, would it occur to you from time to time, or would you think about it from time to time that your cousin was supposedly being touched by his father? No, I really wouldn't think about it. No, I really would think about it. Well, did you suggest to him that you can inquire of an adult without identifying him as a person involved? I was 11 years old. I probably didn't even try and circle around the way of asking like that. The fact of the matter, Mr. 𝐂𝐚𝐬, is that you did not report this to anyone. Is that correct? That's correct. You did not memorialize this in any way, is that correct? I'm sorry, sir. You did not memorialize this occurrence in any way, did you? No. I find that that's a little brutal. I'm not okay with that. They were young, right? Hello, Against All Logic. Good to see you. Laura, guys admit to that kind of stuff, especially back then, for that matter. A lot of people don't tell, right. And back then it was like taboo, right? Like it was something hard to talk about. And it's a culture thing too. A lot of people in different cultures. It's, like I said, it's taboo. If Mr. 𝐂𝐚𝐬 had truly received the 𝐂𝐚𝐬 letter, he would have been a teenager, and the letter would have been a key piece of evidence in support of Eric Menendez's allegations, especially given the defense in both trials. It is inconceivable that neither defense witness, Mr. 𝐂𝐚𝐬, nor Eric Menendez mentioned or introduced this 𝐂𝐚𝐬 letter when meeting with Eric Menendez's attorney or in testimony in two different trials. The timing and the manner of Mr. 𝐂𝐚𝐬's disclosure of the alleged molestation is also questionable. In the second trial, Mr. 𝐂𝐚𝐬 testified that Eric Menendez was in Israel when notified that he had to surrender to authorities for killing Jose and Kitty. Eric Menendez then flew to Florida, where Mr. 𝐂𝐚𝐬 and his mother, Marta 𝐂𝐚𝐬, met him and flew with Eric from Florida back to California. Per Mr. 𝐂𝐚𝐬, not once during their time together in Florida or on the flight back to California did Mr. 𝐂𝐚𝐬 and Eric Menendez discuss anything about the murders or alleged molestation. Also, per Mr. 𝐂𝐚𝐬, he subsequently visited Eric, who was in custody awaiting his trial. During that time, Eric gifted Mr. 𝐂𝐚𝐬 a car. After receiving a car from Eric Menendez and visiting Eric numerous times in jail, Mr. 𝐂𝐚𝐬 testified that he had visited Eric Menendez's attorney, 𝗟𝐿𝐿𝐿𝐿𝐿𝐿𝐿𝐿 Abrahamson, in January of 1991, approximately 9 months after Eric Menendez's arrest, and revealed that Eric Menendez had told him of Jose Menendez's molestation. Mr. 𝐂𝐚𝐬 testified he had never told anyone else, not even his mother, about this. Even more suspect, petitioners conveniently waited to raise the 𝐂𝐚𝐬 letter until after Mr. 𝐂𝐚𝐬 had died, which precludes respondent from examining Mr. 𝐂𝐚𝐬 about the 𝐂𝐚𝐬 letters and any proceedings. As soon as petitioners murdered their parents, they began a relentless campaign to deceive, conceal, and fabricate evidence. Moments after the unaliving, instead of calling 911, petitioners left to buy movie tickets and tried to shore up an alibi with Mr. Berman. Additionally, petitioners had evidence by picking up the shotgun shells, hiding the weapons, and discarding their bloody clothes. The potential that they had to continue to falsify evidence to secure their freedom is not only impossible, but probable. The petitioners have exhibited a clear pattern of practice and deceit which continued beyond the day of the murders. For example, in 1990 and 91, petitioners ardently tried to fabricate multiple pieces of evidence in their underlying case. Before December 1990, Lyle Menendez asked Jamie to look up several legal cases for him, which had been where their children had gotten away with killing their parents. I believe so. Yes, I mean the cases where, child molestation and, children had killed their parents and gotten off. After providing these cases to Lyle, Jamie met with him in December of 1990. At this meeting, Lyle Menendez had asked Jamie to commit perjury and testify at trial that Jose had raped her. When Jamie refused, Lyle tried to bribe and intimidate her into submission by telling her she had to do it because a large sum of money was going to be deposited in her bank account. Jamie refused to testify in the way Lyle Menendez instructed her. That's funny. After Mr. 𝐂𝐚𝐬's alleged disclosure of Eric Menendez's claims of molestation to 𝗟𝐿𝐿𝐿𝐿𝐿𝐿𝐿 Abrahamson, Lyle Menendez sent the 6-page 𝗟𝐿𝐿𝐿𝐿𝐿 letter to Eric Menendez's classmate, Mr. 𝗟𝐿𝐿𝐿𝐿𝐿𝐿𝐿, instructing him to fabricate evidence and perjure himself at trial. In the 𝗟𝐿𝐿𝐿𝐿𝐿 letter, Lyle informed Mr. 𝗟𝐿𝐿𝐿𝐿𝐿 that Leslie wants to interview you as soon as you're in town. She may even come up to see you. The 𝗟𝐿𝐿𝐿𝐿 letter then instructed Mr. 𝗟𝐿𝐿𝐿𝐿 in very specific detail to lie and testify to a made-up incident where the petitioners had been in fear and borrowed handguns from Mr. 𝗟𝐿𝐿𝐿𝐿. In other parts of the 𝗟𝐿𝐿𝐿𝐿 letter, Lyle concocted and scripted lies of Mr. 𝗟𝐿𝐿𝐿𝐿 to tell on various subjects, including that the petitioners were afraid of their father. Petitioners believed their father had been unalived because of Jose Menendez's alleged mafia connections. Eric Menendez had informed Mr. 𝗟𝗏 that Jose had taken Eric out of the will, and Jose's statement about a father killing a son mimicking a scene from the movie At Close Range, which Mr. 𝗟𝗏 would attribute to Jose Menendez. In the letter, Lyle wrote, "Here's an outline of what we need. It is not crucial that your story matches ours perfectly, so don't worry." Lyle also wrote, "Eric and I have told our lawyers the story, except we said there was no gun. You will say there was, and when Leslie says, but the boy said there was no firearm, you will say, I told Eric to say there wasn't a firearm because of my mom." Lyle Menendez instructed Mr. 𝗟𝗏, "I have an untraceable firearm I can get for you to use as the one you gave us if you don't already have one. Let me know over the phone. I'll have Beatrice get it for you." After explicitly and comprehensively detailing the false statements that Lyle Menendez asked Mr. 𝗟𝗏 to talk to their lawyers and to testify in trial, Lyle added the following direction. "That is basically the important facts. There may be little things like Eric told you were taken out of the will a while back by his dad, and occasionally you used to watch videos over at our house with my mom and dad. You once watched a movie called At Close Range with Sean Penn. My dad said the movie was unrealistic because the father would have killed the son as soon as the trouble started and not waited. You, of course, were shocked at the statement. You always felt my dad was a very powerful, scary person. You never felt welcome. Your memory on these things does not have to be that good. Leslie will help tell you what she sort of needs. However, I think that the Saturday Shore and perhaps the movie incident will be enough. Too much is not good. I'll be calling you. Please leave a message on my service when you receive the letter and mail it back to Beatrice. First, write down all the facts you need to know so that you have them to remind you later. Also, scribble over the writing of the letter with magic marker so that it falls in the wrong hands. It is not legible. I obviously trust you completely. However, I sleep better if I'm sure things have been destroyed. Mistakes have been made in the past." In the second trial, Mr. 𝗟𝗏 testified he was supposed to tailor his testimony to whatever petitioners needed in trial. "Did you tell Detective Zoller that at the time when the three of you, that is Eric, Lyle, and yourself, would add dynamic to fit what was needed for trial?" The question is, did I say that to Detective Zoller? Yes. Yes, I did. "Did you tell Detective Zoller that Eric and Lyle Menendez asked you not to come to the jail for visits, as visits would look suspicious with you testifying on their behalf?" Yes, I did tell Detective Zoller that. Mr. 𝗟𝗏 also testified that he had never watched the movie At Close Range and never heard Jose mention anything about At Close Range. 𝗟𝗏 testified that he knew when he had received the 𝗟𝗏 letter from Lyle Menendez that this was a lie. Similar to their manipulation of Mr. Berman, the 𝗟𝐻 letter, the bribes, and the intimidation of Jamie regarding her testimony, and the gifting of the car to Mr. 𝗟𝐻, the 𝗟𝗏 letter evidences unremitting attempts by petitioners to coordinate evidence fabrication to support their false narrative to justify killing their parents through defense witnesses. Given the fact that the 𝗟𝐻 letter contradicts Mr. 𝗟𝐻 and Eric Menendez trial testimony and petitioners' documented history of manipulating and fabricating evidence in the underlying case, the 𝗟𝐻 letter is neither credible nor reliable. As such, the 𝗟𝐻 letter is not new evidence under the current statutory definition, and is not sufficiently material and credible that it more than likely would not have changed the outcome of the case. Moreover, it does nothing to prove petitioners actually believed they were in imminent danger when they brutally killed their parents. Because petitioners totally failed to make a prima facie case of new evidence with the 𝗟𝐻 letter underlying the prevailing legal standard, this court should summarily deny the habeas relief on these grounds. Petitioners assert a new evidence claim on the grounds of Roy Rosella's 2023 declaration alleging Jose Menendez molested him in the 1980s. Even assuming arguendo that the allegations in the declaration are true, such evidence does not meet the statutory requirements for relief on claims of new evidence on the habeas corpus. It is inadmissible, immaterial, and lacks credibility in contravention of Section 1473 subdivision. Initially, petitioners do not establish that it would have been admissible or immaterial at trial. The three questions before the convicting jury were: did petitioners conspire to unalive their parents? Did they unalive their parents? And were the petitioners' respective states of the mind in their respective states of mind when they collectively shot their parents over 12 times? The California of Appeal noted, the trial court stated that the principal issue was the state of mind of the defendants at the time of the unaliving and the relevance of the prior incidents may have made on the defendant's mental state at the time of the killings. The source witnesses were allowed to testify extensively concerning many areas in an effort to determine the state of mind of the defendants at the time of the crime. For example, the appellate court found that the trial court correctly sustained the prosecution's objection to a witness's opinion about Kitty Menendez's child-rearing style, finding that the question was properly objected to by the prosecution because they had concerned behavior of the victims, which was remote in time and not relevant to Eric's state of mind on August 20th, 1989. In similar fashion, Rosellar's current allegation of abuse by Jose Menendez is not admissible or material to the petitioner's state of mind at the time of the crimes because both petitioners claimed not to have learned about Roy Rosella's allegation until more than 30 years after the murders. Eric Menendez declared, "In November 2022, I was told that a former member of the band Menudo would come forward to say that my father had attacked him." In another example of meticulously matched statements, Lyle declared, "In November 2022, I was told that a former band of Menudo had come forward to say that my father had raped him." Petitioner's admissions decimate the admissibility of Rosella's allegation. Clearly, a sexual abuse allegation petitioners did not learn about for more than 3 decades after they murdered their parents was irrelevant and immaterial to their state of mind in conspiring to unalive their parents. Days before the murders and at the moment they unalived their parents, petitioners do not show otherwise. Most importantly, as has been repeatedly litigated in petitioners' direct appeal and federal habeas petitioners did not face imminent danger because they decided to unalive their parents. Rosella's allegation does not change the fact that Eric and Lyle left the house after the confrontation, went to the car, retrieved their firearms, reloaded their firearms with better ammunition, re-entered the house, burst through the doors, and began shooting their unarmed parents. Rosella's allegation decades after the fact does not change the convicting trial evidence or the jury's finding that the petitioners conspired to unalive their parents. Simply put, petitioners make no showing that Rosella's declaration is admissible and sufficiently material and credible that it more than likely would not have changed the outcome of the case, as the Section 1473 subdivision requires them to do so. As such, it is not new evidence entitling them to the relief on habeas corpus. Hey Jeff, good to see you. Petitioner's new evidence claim regarding the Cano letter is procedurally barred as ultimately untimely, and neither petitioner has established a legal viable excuse or justification for its untimeliness. Generally, successive or untimely claims in habeas petitions should be summarily denied. Although we conclude here that it should not be flexible, the general rule is still that absent justification for the failure to present all known claims in a single timely petition for writ of habeas corpus, successive and or untimely petitions will be summarily denied. The only petitions do not subject this rule are the petitions which allege facts which, if proven, would establish that a fundamental miscarriage of justice occurred as a result of the proceedings leading to conviction and or sentence. A petition for writ of habeas corpus petition must be filed as promptly as the circumstances allow. In a habeas proceeding, the petitioner must justify any substantial delay in seeking relief. The United States Supreme Court cautions courts that when a habeas petitioner succeeds in obtaining a new trial, the erosion of memory and dispersion of witnesses that occur with the passage of time prejudice the government and diminish the chances of a reliable criminal adjudication. The California Supreme Court has stated, "We insist a litigant mounting at a collateral challenge to a fine criminal judgment to do so in a timely fashion. By requiring that such challenges be made reasonably promptly, we vindicate society's interest in the finality of its criminal judgment, as well as the public interest in the orderly and reasonable prompt implementation of its laws. Requiring a prisoner to file his or her challenge promptly helps ensure that possible vital evidence will not be lost through the passage of time or the fading of memories. Accordingly, we enforce time limits on the filing of the petitions for writs of habeas corpus and on capital cases, as well in cases in which the death penalty has been imposed. A petitioner bears the burden of establishing through his or her specific allegations, which may be supported by any relevant exhibits the absence of substantial delay. Even constitutional error may be waived, and unexplained or unjustified delay in seeking relief may amount to such a waiver. When an issue of constitutional dimension has been raised, some reasonable delay may be excused, but the excusable period necessarily has practical limits. Delay in seeking habeas corpus or any other collateral relief, as has been measured from the time in the defendant becomes aware of the grounds on which he seeks relief. That time may be as early as a date of conviction. It is no excuse that petitioner represented himself at any point during the proceedings. The burden is one placed on the indigent petitioners appearing in propria persona. A convicted person is not permitted to allow years to pass during which witnesses die, disappear, or forget, and his own imagination grows and expands. In waiting until Mr. 𝐂𝐚𝐬𝐡 died to raise this claim, Eric Menendez weaponized this substantial delay. Eric declares he wrote the 𝐂𝐚𝐬𝐡 letter in 1988. If the proffered date of this undated letter is taken as true, Eric Menendez, its alleged author, knew about this letter even before he murdered his parents. By waiting until after Mr. 𝐂𝐚𝐬𝐡 died to raise the claim, Eric Menendez conveniently foreclosed the prosecution's ability to examine Mr. 𝐂𝐚𝐬𝐡 about the 𝐂𝐚𝐬𝐡 letter. Furthermore, if his declaration on this point is taken true, Lyle Menendez knew about it at least 8 years before filing this petition, yet he provides no credible nor legally viable explanation or justification for waiting until 2023 to raise them. Accordingly, this court should summarily dismiss petitioner's claim of new evidence vis-a-vis the 𝐂𝐚𝐬𝐡 letter as procedurally barred for its untimeliness. In addition, petitioner's new evidence claim regarding the 𝐂𝐚𝐬𝐡 letter does not fall within any of the exceptions to a procedural bar for untimeliness. The only exception to the rules barring successive or untimely petitions are petitions which allege facts which, if proven, would establish that a fundamental miscarriage of justice occurred as a result of the proceedings leading to a conviction and/or sentence. Clark explained the narrow circumstances in which a fundamental miscarriage of justice occurs. The magnitude and gravity of the penalty of death persuades us that the more important values which justify limits on untimely and successive petitions are outweighed by the need to leave open this avenue of relief. Thus, for purposes of the exception to the procedural bar against successive or untimely petitions, a fundamental miscarriage of justice will have occurred in any proceeding in which it can be demonstrated. One, that the error of the constitutional magnitude led to a trial that was so fundamentally unfair that absent the error, no reasonable judge or jury would have convicted the petitioner. 2, that the petitioner is actually innocent of the crimes or crimes of which the petitioner was convicted. And 3, that the death penalty was imposed by a sentencing authority which had such a grossly misleading profile of the petitioner before it that absent the trial error or omission, no reasonable judge or jury would have imposed a sentence of death. 4, that the petitioner was convicted or sentenced under an invalid statute. These claims will be considered on their merits even though presented for the first time in successive petition or in which the delay has not been justified. As the California Supreme Court observed in Reno, the words used to articulate the Clark exceptions to our timeliness rules, fundamentally unfair, actually innocent, and grossly misleading profile, invalid statute, indicate how high the bar is to be a litigant successfully invoking these narrow exceptions. None of these exceptions apply to the petitioner's new evidence claim regarding the 𝐂𝐚𝐬𝐡 letter because this claim is not constitutional. Petitioners are not sentenced to death and they were not convicted or sentenced pursuant to an invalid statute. While petitioners may try to argue that this claim falls under the second Clark exception for claims of actual evidence, it does not. Petitioners objectively fail to make a prima facie showing that this new evidence meets the statutory requirements necessary on habeas corpus. It does nothing to alter the finding that they lacked an actual fear or imminent harm when they unalived their parents. It is not evidence of their actual innocence. Thus, petitioner's new evidence claim regarding the 𝐂𝐚𝐬𝐡 letter is procedurally barred for its untimeliness. As such, this court should summarily deny the claim. Conclusion. Petitioners have failed to establish a prima facie case that they are entitled to habeas corpus relief on any of their claims. Procedurally, petitioner's new evidence claim based on the 𝐂𝐚𝐬𝐡 letter is barred as untimely without exception. Substantively, petitioner's claims fail. Both claims of their alleged new evidence fail the specific requirements of the section. Petitioners do not make a prima facie showing otherwise. For all the foregoing reasons, respondent respectfully requests that this honorable court summarily deny petitioner's petition without an order to show cause and without the necessity of an evidentiary hearing. And we're done. That was filed on February 21st. That was the second part. Yay! I'm so happy we got through it. Melly, when will we find out the final decision? I think they have a hearing again on the 20th. So this week. Yeah, I know I did. Anyways, I'm excited we got through that. So that was the second part of the petition for the Menendez brothers. We'll keep following the case. We have another live after this. Hey, Jeff, thank you. Hope you had a good weekend too. And I hope to see you guys there. We're covering Karen Reed. I don't think they're getting out. I don't think they're getting out either. I actually said this to another friend. I was like, I don't think they're going to get out. I feel like they served their time for what they did, their parents. I know. I don't think they're going to get out though. But anyways, thank you for being here. Make sure you hit that like button. I will see you on the next slide. We're covering Karen Reed. Hopefully y'all can make it. If y'all can make it, then I'll see you tomorrow night. We have a new case tomorrow night. Maybe Karen Reed, maybe new case. We'll see what I'm in the mood for, but wait, what videos? The Menendez Brothers videos? Yes. What time? Right after this, hopefully. So hopefully I see you guys there. Make sure you hit that like. Oh, thank you, Pantera. And shout out to all my mods for being here. I appreciate you. I have to sneeze. What do you mean no go? Oh, let me go back. Pantera, thank you. Thank you. I appreciate you. Oh, you're so sweet. Thank you. Wait, you were talking about Karen Reed earlier? Of course. Today you were? I see you guys talking about liquor. Oh my gosh. Not the 𝗂𝐚𝐬𝗃 contest. Let me ask my husband. I'm trying to go back and chat. Thank you, Pantera. I appreciate you. Is that what you were talking about, Laura? Oh, I have to get on YouTube. I can't do it on StreamYard. Let me see what you're saying. No, we have another live coming right now, so I hope you guys can remember or make it. She turned a blind eye. Oh, the mom? I don't see any Karen Reed comments. The DA sucks. Why the hell does he have such a hard on for the Menendez brothers? I know he does. Let me get back to the... Oh, yeah. I'll play them. Yes, I'll play them on the Karen Reed. On the Karen Reed live. Anyways, okay, hit that like button. I will see you guys shortly on the Karen Reed. Hopefully you guys can make it. Thank you for being here. And again, make sure you hit that like button. I'll see you guys soon. Bye.